Introduce our first speaker. That's Lindsay Hall Harrison. She's an underwriting counsel at Stewart Title Guaranty Company. Lindsay has previously practiced as a litigation attorney, representing lenders and servicers in foreclosure proceedings throughout Florida's courts, managing partner of a boutique real estate law firm and title company, and was previously associate general counsel of a large national mortgage lender. She's recently served as business co-chair of the Property Records Industry Association, PRIA's Redaction Work Group, participated in Florida's Task Force of Redaction, and sat on the American Land Title Association's Real Property Records Committees, where she co-authored an associated white paper on redaction. So Lindsay, please talk to us about confidential records, identity shielding, and balancing privacy in land records.
Well, thank you very much, Sandy. I really appreciate you extending the invitation for me to come and speak to this group today. As Sandy said, I think we've got a small enough group that maybe we can definitely do some questions in the chat box while I'm talking. And then we will take, I'll take a few minutes at the end of the presentation to make sure that we have time for questions, so that if there are additional questions, we can discuss them through. So I'll go ahead and get started. As Sandy said, my background is pretty varied, but it is definitely rooted in the real estate and title insurance industry. And I have spent a considerable amount of years sort of working around title. I have closed real estate transactions. I've worked on the lender side, and now I'm on the insurer side. So I come to this presentation and to this issue with a tremendous amount of background and understanding of where we have come from and where this issue really sits, particularly here in Florida. But over the past year and a half, I've been working on a national level as well to address some of these issues. And so today we're going to talk not only about how things are have been going here in Florida, but also how we've been dealing with this issue on a national level. And we're going to get into a deeper dive on some of these states that are continuing to make redaction laws. So the one thing I think is a good takeaway is that even though Wisconsin as a state is not yet facing this in the legislature, do not assume that you will be immune. In fact, I would say sooner rather than later, it's probably a guarantee that legislation which does involve confidential record shielding and redaction will come up. So if it hasn't happened already, don't assume that it won't. That's sort of the message for the national audience, is that this is a thing that most states are going to be dealing with. And we are seeing dealt with even on the national level right now in the Senate and Congress. So expect to see more in the future. So today I'm going to talk about privacy and AdCon laws in general, give everybody an understanding of what we're talking about and an overview of it. Then I'm going to talk specifically about what has happened in Florida over the last 18 months, because we have been really, unfortunately, a poster child for how this process can go very, very wrong quickly. And then I'm going to talk about some of the other states' laws that are on the books now, new laws that are coming, and future pending legislation that we are anticipating may get passed. And then advocacy and solutions, which all of us can take back to our respective counties, to our legislators, and as a lobbying function to try and make sure that laws going forward are done smartly and with the considerations in mind that the recorders and affiliated businesses really have to consider in all of this. So go ahead and get started. The first thing I think we should talk about is the evolution of online privacy. There has been a significant step forward, just even in the last few years, with the discussion of privacy rights online and who has access to information. Back in 2016 in Europe, the European Union brought forth the General Data Protection Regulation Program, which is known as the GDPR. Many have probably heard of that. What that did was it really started an entire avalanche of technology facing issues for privacy, and that got adopted in California in 2018. basically regulating what internet information content aggregators and companies are allowed to collect about individuals and how they're allowed to have that information out online and processing and distributing and disseminating and selling that information. So although that's not what we're necessarily talking about because we're talking about government records, it's important to understand that this is a movement not just on the government side, but this is a movement worldwide to really rein in and have a firmer discussion on what we are doing with privacy and what our information is doing out there on the internet and who can see it and who can touch it. One important concept that I think is really important to all of this is data brokers. Data brokers have been around for a very long time. Obviously, people who aggregate information and then they sell it, or they collect it and then they sell it along. Their first instance of data brokers being discussed on the national level for privacy was actually in 2006 before Congress. And there's a huge report on the information that was gained during the testimony and the conversations in Congress. And that was 2006. That's a long time ago from where we're currently standing, which tells you that this issue has been around for a long time. What is happening with our information that we're putting out there on the internet? Who has access to it, and how is that information being disseminated and manipulated? So when we're talking about data brokers, we're talking about companies like LexisNexis, Experian, US Search, and other recording information aggregators. Title plants also were included in that. So if you are talking about land records, and title plants in many, many states are the primary source of the records these days, especially for the title insurance industry, the data brokering that is done on that level is included in a lot of these plans. So something to keep in mind when we're talking about data brokering is that does include title plants. So what are we talking about here when we're talking about confidential record shielding? And we're actually talking about three different concepts. Over the last year, the PREA Redaction Work Group, one of our main priorities was actually to sort of break down what it is we're talking about so that we could be more educated and be more educating to others in terms of what we're seeing and how to identify it. So if you don't know what it is and you can't label it and identify it, it's really hard to discuss it. So we set about the first thing was to try and categorize what we are seeing out there in terms of legislation, and so we came up with three different categories to really kind of delineate the different processes. The first is redaction. I like to call this pure redaction. This is what we understand to be redaction from the court records. So clerks have traditionally had the access to record documents and in the courts, and oftentimes there are sensitive pieces of information in those records that need to be redacted. And so that's what we call pure redaction. AdCon, that's address confidentiality, and I'm going to talk about that in a bit more detail in a minute, but that's a completely separate program, and that program is really intended to shield domestic violence victims, human trafficking, people who have been victims of crime, and their information is shielded and protected in a different way because they are actively afraid that there are people who are known to them who can come after them, and so they have imminent fear that their information could be discovered by someone who's trying to find them. So there are programs in many states to protect those people. Then what we're talking about third is confidential record information shielding. And this is actually the one thing that really has been on the rise in the last couple of sessions in the legislatures around the country, and this is the thing we're seeing more of, but it does tend to get blended in with the other discussions on redaction and AdCon. And so it's important to delineate out what this is so that we are better able to identify it and to address it. So I'm going to talk about each of these individually, but I wanted to at least put up an introduction on these three concepts, so while we're walking through them, we have an understanding of what it is we're talking about. So when we're talking about redaction, pure redaction, the first thing that's worth mentioning is that PREA does have a redaction best practices paper, which was published in 2014. And if you haven't had access to it or you haven't read it yet, I'm happy to make it available to people who want the information. If you are a PREA member, it's available on PREA's website. It provides guidance for recorders and legislators on defining PII. And how PII is defined is the combination of an individual's name along with another piece of personally identifiable information. So a social security number, a driver's license, a bank account number, your date of birth, an email address, and a mailing address. All of those constitute PII when they are combined with someone's name. So that information in and of itself, when it's found in the court records, has traditionally been redacted. Obviously, if we're dealing with a minor and it's a court case, the minor's name might be redacted. Social security numbers, of course, are something that have been redacted, dates of birth, such as that. All of that type of information is already well established as being redacted. And PREA did set out guidelines for the best practices for doing that. Some of the other best practices that are in this white paper and are really very prescient, because this was written in 2014, but it really did anticipate the future of what we would be looking at when it came to confidential record shielding. Best practice suggests that we should use an automated redaction software for covering up the data from digital images. So not hard redacting an actual piece of paper, but using a digital imaging system in order to do that. One of the pre-initiatives that we have been working with as part of the redaction work group is getting the land record management systems, the LRMS vendors, on board with making sure that this is part of their software, and trying to promote the fact that this should be across the board a best practice for the software vendors to be able to offer this as a technology to their customers. One of the other best practices discussed in the paper is open access to the redacted version while maintaining the unredacted copy as the master. So of course, we don't want to have the only version of an instrument be the copy that's been redacted. So trying to find a way to make sure that the technology is available to do that. And if it's not, that there is a safe place where an unredacted version of a document is being maintained. So here's a great quote that I've pulled from the white paper. I think it's really important. I think it really speaks to what we're dealing with right now. Lawmakers should also be mindful to ensure that legislation does not adversely impact constructive notice elements in their jurisdictions so as to impair the chain of title for real property. Some information is widely available online, and embarking on an expensive redaction effort may not actually result in protecting individuals' privacies. Wow, that's quite honestly, that's literally part of the conversation that we are having around the country right now and on the national level is, are the practices that are going on, is this legislation actually helping to do what people are hoping it will do, or is it just hindering access to the information for the people who need it? And so we're going to talk more about that as this discussion goes on, especially when we're talking about legislation. So when we're talking about AdCon, address confidentiality, what this is, again, is to protect a certain class of people who have an imminent fear that there is somebody out there that they know who is going to hurt them. So this is not an illusory fear that the general public will have access to their information. These are specific people who, under court order or other mechanism, have been admitted to a program within the state. So 87% of people around the country can be identified using only their 5-digit zip code, their gender, and their date of birth. So those 3 small pieces of information make it very easy to find somebody. And of course, if you go on the internet and you just Google yourself, you can see all of these data broker companies that have got access to information. And more than likely, they'll probably be pretty close on nailing your age, and they probably may even get your home address, and they might know your kids' names and things like that, because the information just is out there. It's just out there. So victims can be identified using public records such as voter and driver's license registrations. This is where this AdCon program really came from, is because victims were finding that they didn't have access to be able to register to vote or to change their address on their driver's license, because that information is public record. So 38 states have some form of an address confidentiality program. Utah has a bill in their legislature this session that would make them the 39th state to bring an AdCon law on board. Identity shielding programs for victims does range across the board. Some states have it very narrowly tailored for only certain types of individuals, domestic violence, sexual assault, stalking, human trafficking. Others have broadened the category slightly, but it does tend to remain for a specific type of victim. State address confidentiality law programs do give a legal address as a substitute. So it depends on the state and how they've administered the program. Some states will do it that the address is actually the state's mailing address for particular like a physical address somewhere at the state capitol. Some do it with a post office box that is in a region. Some will do a county office. It depends on how it's administered in the state, but generally people are given a dummy or a ghost address, so that if they put their address on something, mail will go to that dummy address, the official address for them, and then their mail will then be forwarded to them individually. So they don't actually receive mail at their home address. But of course, the program knows exactly where they live because they have to actually send them real mail. So that's generally how it works. Some states have the program running through their Secretary of State's office. Some run it through the governor's office, others through the Attorney General. So it really depends on how the state is administering it, but they generally follow the same rules and the same guidelines, which is to provide a dummy address and give people assurances that their information is being kept confidential from the general public. So now we're going to talk about Florida. Florida, of course, where I am right now, and we have been going through problems with our redaction law that was implemented. I think it's worth going through the case study, really, of what we've been dealing with in Florida. It's been informative for other people in other states to try and understand how not to do things. And of course, being Florida, we are always famous for finding a way to do things quite differently than other people. I'm sure somebody out there remembers hanging chads. So Florida has a long history of being different. So we'll talk first about Florida Sunshine Law. Florida has a very broad public records law, which allows almost everything to be open and under the sunshine, as we call it here in Florida. So open records, open meetings, open access to requests for information. So freedom of information requests in Florida are very, very broad. In order to limit that freedom of access to information, there is a specific statute, Florida Statute 119.071, which is an exemption to the Sunshine Laws and allows for certain records that belong to public employees to be shielded from public access. And those were meant originally to be government workers for like their private data, personnel files, employment records, health documents for spouses and children, that kind of stuff, things that really didn't need to be out in the public, but because they belong to a government worker, were subject to sunshine. So this is a limiting law on that sunshine request and that sunshine access. So the law was intended to protect the confidential information of those individuals while also still maintaining the access to overall records and under the sunshine. What happened in 2019 was that Senate Bill 248 was introduced, which changed the definition of home address, which was part of the 119.071 statutory requirement for disclosure of information. And it allowed the home address of the individual who's the government worker. It allowed them to be limited in terms of obviously their information being shared. Home address was defined, was actually updated to be defined to include the parcel ID number, plot information, and the legal description of the address. So all of a sudden, we now have confidential records which belong to government workers and a variety of other protected parties who have been dropped under the exclusionary law. All of a sudden, the home address is now expanded to include the legal description. That means documents that have the legal description on them are now subject to redaction. And so people took advantage of the opportunity to redact the legal description out of their official records. And you can see where this might be a problem. So immediately after this law came into effect, the Florida Land Title Association, we looked and went, oh my goodness, what has happened here? We didn't see this coming, to be very honest with you. We were aware of it in the 2019 session. We had heard of the bill, but because we really genuinely had not examined it and taken a look at the unintended consequences of it, we did not aggressively oppose it. Because, of course, we were recommended not to oppose it, we would be seen as opposing first responders and judges. And so who wants to be on the bad side of trying to protect the privacy of first responders and protected parties? So it was politically difficult to oppose that. And so as an industry, we did not. And then we ended up facing this law in real time. And since then, we have done a total turnaround and tried to discuss how to get this fixed, but it has been quite a difficult process. So in Florida, because 119071 did include government workers, it also had an opportunity for additional classes of protected parties to be added to that group. So Florida has over 26 different categories of people, and every legislative session, they add another category. So in the last session last year, 4 additional types of categories of people were suggested to be added to the list of protected parties. Those included emergency room workers, judicial assistants to judges. I think there were a couple of county officials, and other parties that are sort of ancillarily related in terms of their sensitivity of their job to the public, but that also includes other groups of people who are already in their Department of Children and Families, so caseworkers who work directly with families. Prison officials were already included in there. So there's really a very broad group of people who actually already are afforded the protection. And as I said, the legislature continues to introduce bills every year, adding more categories of people. Fortunately, last year we didn't have any actual additions, but I anticipate we'll see that again this year. So the requests for redactions are made. If you are a protected party in Florida and you are allowed to have your information redacted, then you have to make a specific request for that information to be redacted. In Florida, we also have separate bodies for the tax collector, the clerk of the court, the property appraiser, and the election supervisor. And so those are not all warehoused under one government entity. They're all separate. So if you want a request for redaction, you have to make an individual request to each of these different entities. They all have their own system and process for doing that. Where this has come in to effect really is with the recording side of things. So the recorder's offices have received numerous requests for redaction, and that information that's being redacted is they're asking for the legal description and their spouse's names from their information. So how the law is written, it says the home address, telephone number, date of birth, and photographs of the insert job title here, that'd be the government worker or protected party, the names, home addresses, telephone numbers, photographs, dates of birth, and places of employment of their spouses and children. So it is very broad when you consider that there's 26 categories, and each of those categories now you can include their spouses and children. We did talk about this in concern over what happens when you have protected parties who are married to each other. If you are spouses and your spouse is entitled to that protection, the people cancel themselves out, and we're going to see that in a minute. So how does the redaction occur in Florida? Protected parties can make the request to the recorder's office to redact the specific documents of their choosing. The recorder's office is not in charge of going and scouring the records to find everything associated with that individual. It's the individual protected party requesting the redaction who makes that request themselves. They go and find the book and page numbers of the instruments they want to have redacted, and then they provide that information to the clerk. The recording office does not verify or confirm the records. So whatever it is the protected party says they want to have redacted, as long as that information has their name on it, they will redact it. Some counties have been unable to hide redacted versions of the documents depending on the LRMS vendor that they are using. So once again, going back to the PREA best practices, hopefully that there is a mechanism in place to keep a separate copy that is unredacted from the original records. That does appear to have been in place in most of the Florida counties, but it is still something that some counties don't have the software to do it. So they are actually keeping and maintaining physical records of the originals because they can't hide them. Their software doesn't allow it to happen. Also, protected parties have to make a formal request in writing with a notarial affidavit to have copies of unredacted documents available to third parties. So this is something that has come up in real estate transactions when someone sells their house or finance it. And all of a sudden you realize, oh my goodness, the protected party now has to go and obtain clean copies of the documents, because the ones that are being requested and the ones that the title search and examiners are seeing have the redacted information. So request to have to go back to the recorder and to get an unredacted version. The recorders are not keeping the redaction requests for obvious reasons. That's a massive amount of paperwork and extra burden on the for unredaction is basically treated as a new request. And so the information that's on the unredacting request has to match the information on the redacting request. But we in the title industry have no way of verifying that information, that everything that got redacted is also getting unredacted. So I'm sure you can start to see where we might have a problem there too. Here's an example. I want to give you some examples of what we've seen in Florida in terms of redaction. So here is an actual deed, Space Coast, anyone who's been to Cape Canaveral, this is Brevard County. And here we have the individual, so the grantor, we can see their names, and giving it to the grantee, and you see the second name has been blacked out because that is the spouse of the protected party. And of course, under the statute, the protected party spouse can be redacted, their name. So they're missing their home address. And we're also missing the legal description and the parcel ID. So if we're talking about how do we know what record we're looking at? The same thing on the next, the other half of the page there, that's a notice of commencement. That's a construction lien. That's what we call them in Florida. So the contractor will file something like this in order to be able to start work on the property. Well, under Florida law, there has to be constructive notice given to the parties and to everyone else that work is being started on the property. The lender needs to be able to be aware of it through constructive notice. And also any other contractors or material men who may be servicing that property, they would rely on this notice of commencement for any liens that they would want to present to the property. So if they can't find the individual because we don't have the legal description and we don't have the homeowner's name, how are they actually perfecting their lien? So again, questions that we don't have answers to yet. Here's a mortgage. This is a traditional mortgage here in Florida. As you can see, this is by the same borrower who his wife was on the deed and her name was scratched out. Well, here we have a black box around her name, so we don't know who the spouse is. I used to work in foreclosures back 2010 when foreclosures in Florida were the big thing. And, you know, in order to be able to be the lender to obtain a proper foreclosure and to retake possession of the home, you have to make sure as part of the procedural steps in the court case that you have served all of the homeowners and that you have actually been able to give them notice that you are going to retake their property. In this situation right here, we don't actually know the name of the borrower's spouse. So if you're relying on this recorded mortgage as the instrument to give you that notice to file the foreclosure action, as the lender, it would be very difficult to claim that you have specific notice in this case. Also, if you can see on that third screen right there, the signature's been removed. So arguably, an affirmative defense filed by a clever attorney who sees this recorded mortgage say, I didn't sign that. You can't prove that I signed that. You don't have a clean copy of it. Florida has also been notorious, unfortunately, during the foreclosure crisis, especially where original mortgages were lost in the court. Either the original mortgage lender had it and accidentally lost it. So in some cases, many cases I actually prosecuted and worked on specifically, we had situations where the recorded mortgage was the only mortgage we had, and there was no original anymore. And so we were relying on an affidavit to the court that this mortgage is a true and accurate copy of the original. Well, if this was my case and this was my situation, I don't have the borrower's signature. I have one of them, but I can't claim that I know that both borrowers signed this because that instrument has been redacted. Here we go on the back page, just so you can see this is where the notary block is. And again, we don't have a sufficient acknowledgement here because we don't have the spouse's name. And as you can see, the Exhibit A, that's where we would have the legal description to the property that's being mortgaged. We can't see it. So what did they mortgage? We have no idea. If this individual has multiple properties, perhaps they have primary residence, they have a beach house, they've got an investment property, which house have they mortgaged? What property are we actually dealing with here? We have no way of knowing. So I've kind of given you a scenario and sort of laid out the groundwork so we can really talk about what are the unintended consequences of this. And as you can see, there are many of them. Home address under the definition in the statute is open to interpretation. Does that mean the primary residence? Does that mean investment property or rental property or property that the protected party doesn't even live in? There's no specifics on that. So under the different counties' interpretations, most have interpreted that to mean any property owned by the protected party is subject to the home address. So that information can be redacted. There's no sunsetting provision in the law currently. So that means that some of these redactions will live in perpetuity. There are provisions with ceased protected parties. Protected party dies and their spouse death. There is no mechanism under the statute for the protected party's spouse to be able to request the documents to be unredacted. It has to come from the protected party. That notarized statement asking for the unredaction has to come from the protected party themselves. If they're deceased, I don't know how you do that. The married protected parties issue, I mentioned that already. If you've got a police officer married to a judge and they're both under the statute, they cancel each other out. So I have seen deeds where you have two names blacked out. And the legal you have to notice to anything. The statute says children, but that's not specific to minors. So theoretically, if my parent was a protected party, I'm an adult, I own my own house, I have my own family, I live somewhere completely different, I'm still privileged under that law to have the protection. Well, does that now means there's a whole separate group of people and their property that are subject to this as well, and their information can be redacted. Of course, title searches are taking longer because there's additional stuff that needs to be done, and there's additional examination that needs to be done, and there's additional to be asked. It's made it very difficult for a lot of transactions to go through. And in fact, some cases we've actually had transactions that have been canceled because there was no way to verify information for a protected party. I don't like to bring it up, but fraud is an actual serious consideration. I mentioned at the outset, the protected party is the one who picks and chooses which documents they are having redacted.
Excuse me,
Yes.
Lindsay. We're getting a little bit of lag time. Somebody suggested maybe
Yes.
turn off your camera and maybe that might help since you're frozen anyways. We can't.
Yes.
Really, okay. Let's try that. Oh, now what happened?
See if that'll fix it.
Okay.
How's that? Can you still see my video?
Yep, we're still seeing the shared screen that Brandon's sharing, I think. And we can still hear you. Thanks.
Okay. Okay. All right, great. So on the issue of fraud, we don't want to talk about fraud, but unfortunately, it's something that is actually a real concern. As I said at the outset, protected parties pick and choose which documents they're having redacted. So a smart person who understands how this law really works in operation may decide that they're going to sell their house, and they have a mortgage, they have a deed, they also have 3 or 4 judgments recorded against them. They may decide to leave their mortgage and their judgments. So when a title search is done on the property, the mortgage and the deed are found, but there's no judgments found because, of course, they're redacted. So we don't know the names of the parties and we don't see the legal description. We don't know that those are attaching to that specific property. So there's an opportunity for fraud there because the title searcher would not be able to necessarily find those judgments. They would just pass on without being addressed. So there is an opportunity for fraud there. It also, again, creates additional burdens for the protected parties because the protected party has to go and make the unredaction request. So as I said before, sometimes these requests happen at the last minute, and that can delay the closing. All right, so let's move on and talk about other states, this legislation and what that legislation looks like. So Arizona is one of the first states to bring in this type of protected party legislation. And the way that Arizona has done it has actually turned out to be sort of a model for how ALTA, the American Land Title Association, and PREA, and how we recommend other states follow. So we're very pleased with Arizona's law. We think that they have done it sensibly, and we think that there is lots of opportunity here for the law to be done, to be implemented correctly, maintaining both confidentiality for the protected party and also maintaining the integrity of the land records. So the law allows an eligible person to request restriction from the general public to have access to their information. They can make a request in writing. They need to specify to the protection. That request is then logged into the clerk system, and it is forwarded over to a judge. And there is actually a formal hearing on the issue, and the judge makes the determination of whether or not the protected party is entitled to the protection. And if so, then there is an actual order, a court order that allows for the protection. When that happens, then the clerk is then given instructions and directions on what information is going to be redacted or concealed. And we're really talking about shielding at this point because it's only the online records that are actually being affected. So the publicly facing website access to this information online is what we're really talking about here. And that's what the law in Arizona is covering. So the affidavit that comes from the protected party has to have their name, address, their legal description, parcel ID, their job title, and the reason for the request. So it has to have a lot of information, and there has to be a diligence. The sunsetting provision is built to it. So the protection is available to the party for 5 years. And then after that, if the protection request is not renewed, it expires and information becomes unshielded again. This is convenient for a lot of ways. Certainly people change jobs and no longer need the protection. Other times people move out of state or people die. And in all of those cases, the information goes back to being open to the public record because people still sell and buy real estate even after someone is no longer needing the protection. And so it puts the official records back into place and back to receive that protection when they need it, but the records are maintained. So to give you an idea on the Arizona law, they don't quite have as many categories as Florida, but as you can see from this list, there are quite a few categories of people who are entitled to the protection under Arizona, and the law seems to be able to accommodate all of them successfully, while also maintaining the constructive notice that is really required. So there is an opportunity for the information to be released to the title industry if it's needed. And that mechanism does seem to be working itself out. So the title insurance, land records, mortgaging have not necessarily had any issues and slowed down because of this law. So this is a good thing. We hold Arizona out to be a model for legislation. So if you have any questions, please show up next week to the PREA conference. We will be having a conversation with the recorder from Maricopa County in Arizona, and she's going to be talking specifically about how this law has been implemented and how it's working in her state. Maryland is another state that has got
Lindsay,
pretty good. Yes.
Before you move on from Arizona, we got a couple of comments in the chat wondering, doesn't that bog down their court system?
Well, it's seemingly the court system they have the volume to be able to do this. I don't know whether it's a circuit judge or whether maybe they have a hearing officer who's handling this, but I don't believe that they're getting thousands of requests a day. I think that these requests are trickling into a manageable level. I haven't heard anything about the court system being bogged down under the requests.
Okay, we're still getting some lag. I think we're still hearing all the words, except they're just kind of sounding very strange. Not sure what's going on, but I think we're hearing everything that you're saying. Another comment: if the Arizona law expires in 5 years, how does the clerk know to unredact? Is that something that they're responsible to keep track of the time frame?
Under the Arizona law, the software is actually handling the unredaction. So they already have a system in place to be able to unredact using the software. So either that's being used has a time counter in it and is able to unredact the information as needed. And I say unredact, I really mean unshield, because it's really only the publicly facing website information that's actually affected. It's not the official land records themselves. It's the access online to the public.
Okay.
Moving on to Confidentiality program in their state. The reason it's worth mentioning is because the AdCon program provides for a provision for protected parties to be able to have their information shielded. And so in similar ways to Arizona, there is a consideration for the fact that people are actually engaged in the purchase and sale of real property. So that information is able to be, the information is able to be unredacted and released. So the address confidentiality program there is limited to victims of domestic violence, sexual assault, and also minors. But the program does provide for a fictitious address. And it does give the title industry the needed access to the records to obtain copies of the originals. It is actually under a separate code, regulatory code, but the two statutes do work together in order to make sure that the information can be readily obtained when it's needed. It's for the purposes of performing a bona fide title examination is what the statute says. And the request is made in writing to the Secretary of State's office. And the person gives the name, the title, address of the property that they're looking for and who they are in making the request, and the disclosure that the information is going to be used to perform a bona fide title and back to the title company within 2 business days. So they have set up a system there where the information is able to flow freely between the disclosing party and the government. I want to move on and talk about New Jersey. This is very new, but many of you, I'm sure, have heard of it. Daniel's Law is the name of the law entered that late last summer, Judge Esther Salas, her family was attacked in their home. A crazed attorney who he did not like women, he did not like women judges, and so he took a gun and went to her house, and her son Daniel answered the front door, and this attorney shot him dead on their front steps. It's an extremely terrifying story for judges, but Judge Salas's information was found online, which prompted the New Jersey Assembly and the governor to move quickly to implement a law which was sure that this never happened again. What the law has done practically is quite different, and has a numerous number of unintended consequences in effect. But the goal behind it was to prohibit knowing and purposeful disclosure of online information, including home address, the telephone number, And email addresses are also their families, and that is for active or retired. The state and local government, this is also of great interest to recorders around the country because the law specifically states that government agencies shall not knowingly post or publish on the internet. So even though the effective date of this law doesn't happen for another, I think it's 16 months at this point, there are numerous stories that can be found coming out of New Jersey, recorders and clerks across the state who are madly scrambling to find all of the information they can about retired judges, current judges, retired prosecutors, and police officers, and to find a way to hide that information because the law, when it goes into effect, could effectively penalize those local government officials for that information being out there in the public. It's quite a dire situation, such that there is a request from recorders around the state that has just gone to the governor and to the attorney general, begging, pleading for guidance on how this law is supposed to be followed and how these different offices and officials are supposed to implement it. And it's going to be a great interest to all of us around the country to watch over the next year and a bit to see how this actually goes into effect, because there are a huge number of people who are affected by this, and there's seemingly not a lot of guidance on how the recorders are supposed to go about implementing it. One example is that in a small county in New Jersey, the local magistrate judges are hired and appointed by the council, the county council. And of course, as part of the process, their resumes and CVs are submitted to the public record because they are for consideration as part of the minutes of those council meetings. Well, the county is now scrambling to go back in time and find every appointment for judges ever made, because all of those judges are going to be affected by this. And so all of that information has to be found and then shielded. The biggest concern is, how do you know which judges this affects? And if these are retired judges, how do you find them? There's not just a list of retired people out there who would be affected by the law.
So do they, as in New Jersey, it's automatically all judges and all the protected parties, without differing from the other states, in that they don't have to actually request it. It's an automatic that they all have to be protected.
That's right. The law is working both retroactively to all records already in existence, and any future redaction requests or shielding requests made after the law is implemented within 18 months. Those record requests will go to the clerks, who will then have to also go in and shield and hide those records going forward. So any new purchases of homes or mortgages or anything else like that, protected parties would then be able to make those requests going forward as well. But it is retroactive, which is the part that's really bothering the clerks right now, is how to implement that.
That would be very difficult to navigate. One of the questions is wondering if there's any funding source being given to the counties for the clerks and the recorders to redact this information.
Not that I am currently aware of. I know that that is part of the request, is for funding and for assistance, not only guidance, but also how is the manpower going to be allocated in order to do this, and how are people going to pay for the additional manpower in order to make sure this is done. So again, this is part of the concern with how this is going to be implemented, which is why we're watching it very closely, because it is kind of a fast-moving target. New Jersey New Jersey Senator Menendez has also proposed a bill on the national level. He brought it through in the last session, and it was proposed, which would have made a national redaction shielding law, and would have provided for some funding source for states to be able to implement these programs going forward. The national law would only obviously affect federal judges and federal law enforcement officers, but there was a mechanism in there to provide funding to states in order to pay for this, but it died in the last session. There is strong suspicion and hope that it's going to come back up in this session. And ALTA is working very closely with the Senator's office and staff in order to try and help to craft the best bill possible to address all of the concerns that we have seen on our side. So stay tuned for that. There will be more information about that coming. To jump on to pending legislation around the country now, I just want to touch on these briefly. Any of you who were on the call a few weeks ago that Priya hosted, I apologize if this is revision information for you, but we were talking about legislation on redaction, and it seems since a lot of this is still very current, it's worth discussing. Again, just because it's not in your state yet doesn't mean it won't be. So some of this information is very educational to see how other states are handling the requests, and particularly when you have legislators who are trying to make a point rather than to make good law, how some of these are actually coming across. So Arizona, just as we've talked about Arizona, there is actually an amendment to their current bill, or to the current law, I'm sorry, which is going to expand the shielding program and will give additional program participants access. So hearing officers, former public officials, including judges and prosecutors, would be included under the law. So it's expanding the class of persons. Under Missouri, there is a House bill right now, House Bill 59, which is only specific to law enforcement officers. It doesn't include judges or anybody else. But it would specifically require that the electronic records that are maintained by the county shall not be disclosed, shall not disclose the home address or personal information of the officer, or use a data element that discloses the information. So data element is not a defined term. And having experience in Florida where we don't specifically define terms, we get ourselves into trouble. In this case, in Missouri, the data element could potentially be the legal description. Because this is an undefined term, we don't know how this is going to turn out. But fortunately, Priya is working very closely with recorders in Missouri, and Missouri recorders are working very closely with their Land Title Association and the legislators to try and make amendments to this bill while it is still in bill form before it gets passed. So stay tuned. Nevada has a current address confidentiality program, and this bill would amend that program to require county recorders to maintain the personal information in a confidential manner. How? We don't know. What that means in terms of implementation, we don't know. But the requests for the confidentiality will have all document numbers and records that contain the confidential information must be shielded. So again, implementation on these programs is key. And what really is important is education for the legislators who are proposing these bills, to explain to them very clearly what it is that recorders do, how their jobs are done, and how the information is held so that the laws can be crafted as narrowly as possible to maintain the integrity of the records. Other states, we've got Oklahoma has a Senate Bill 858 requiring county clerks to keep information of when requested by the officer. The information is the home address of the individual, spouses, minor children, telephone information, and email. So they do not have some sort of illusory term like data element. So we're not necessarily concerned that the legal description will get sucked into this. But I don't see that it would be a far reach for that to be done if the term had the Florida problem. If you don't define the term, you can expand it. And then here in Florida, fortunately, our work through the Land Title Association, through Priya, and we have been over the last year working through a work group established under a state senator here who heard the pleas and cries of the Land Title Association. She convened a task force over the summer, brought the interested parties to the table, including the Clerks Association, the Sheriff's Association, and many other, the mortgage bankers and other groups and interested parties together. And we are working on a bill that has been introduced in the Senate and in the House, a companion bill, which would be the legislative fix for Senate Bill 248, which passed back in 2019. So that would create a specific path for access to shielding the documents So we would only be shielding electronic, publicly facing website information. We would not be shielding and redacting the actual official records themselves. It would require the recorders to maintain a visible online grantor-grantee index, because currently the grantor-grantee index is part of the redaction. So if you do a name search, that name is currently hidden or redacted from the record, so you can't even find the record in the first place. So this would at least maintain the integrity of the grantor-grantee index, so documents could be found. Even if you can't see the actual document, you at least know it's existing, which would certainly help with constructive notice. The protected parties will still have to file the request for shielding. We haven't figured out a way around that problem, because it's too much burden on the clerks to ask them to go and find all of the documents for the protected party. But it seems to be a balancing act at this point. And the one thing is to allow the protected party to continue to make the request. But we have included a sunsetting provision of our own, tracking with the Arizona one. So hopefully, if that passes, there will be a way for those documents to be released back into the public at some point. It'll also carve out protections for data brokers, such as title plants, to maintain the unshielded access so that the information can continue to be there. Really quickly, I do want to talk about the efforts that have been going on in terms of the industry. So American Land Title Association and PRIA, as I have mentioned, have been very actively working on this for quite a while. The Alta white paper, which was crafted back in 2019, has been very actively used at the state level to assist in educating legislators about the unintended consequences and the possible concerns that may be out there with creating laws, trying to regulate and impact the land records being managed by the recorders. So it's a very interesting white paper to read and to also disseminate to legislators. It's been seen as very helpful. And then, of course, I do want to bring to your attention that we have got some new publications through PRIA. These are joint publications with Alta, and there's 3 of them that they are readily available. So if you are considering that legislators do need to get more education on this subject, I do recommend these documents. We have a record shielding FAQ, the information shielding best practices, and also a Judicial Security and Privacy Act information one-pager, and that is specifically about the federal legislation that's going on and how best to craft that legislation going forward, and to talking points for legislators. So you're aware that this is coming to your state, or your legislators are talking about it. The preliminary suggestions is to stop redacting the official records. We want to strongly discourage the actual redaction of the official records themselves. Those are our land records. That's the way that we convey property in this country. It's very important that we maintain those records, and that they're unimpeded. Sensitive records or protected parties to be shielded should be done only for the online records. And that can be done in a system similar to shielding records, or to the sealed records, which court cases have records sealed all the time. There's certainly a mechanism for doing that. That would be a similar process that could be implemented in many states quite easily, since the software in most systems allows for that constructive notice, and that the industry has access to the land records in order to be able to continue the processing of real estate transactions. That it will not affect title plant or vendor access. That information is very important as well. And then, of course, that no original records will be redacted. So we want to make sure that the original records are left intact and maintained in their efficacy. That is it for me, and I want to say thank you very much for having me present. I know I'm out of time, but if there are any questions, I'm happy to take them if we have time for them.
Thank you, Lindsay. Yep, there are a couple of questions in the chat. Well, I think there's only a couple, so we'll quickly do those. Are recorders and clerks provided with a specific list of documents that must be removed? And I think, Kyle, that came from the New Jersey, when you were talking about the New Jersey law. Is there specific documents?
No, it's not a specific list of documents, it's specific people. So in New Jersey and other states, it's any document that would have that individual's name on it. So, I mean, it could be anything. As I said, about us, the resumes of judges who have applied for magisterial positions. It's potentially if a judge decided that they were going to have a barbecue at their house back in 1975 and their address was on the invitation and that invitation was kept in the records, that would have to be redacted. So there's no specific guidance on what documents. The only guidance so far is on the individuals that their information has to be removed. But again, there is no list of people who are retired judges, retired police officers, retired prosecutors. So that in and of itself is quite a challenge to try and go back through and find these people who need to have their information redacted because they're not known necessarily. So it's very difficult.
It certainly makes more sense to me to have the requirement that they request that the information be redacted. That would, so that they know who really wants that.
Right.
Yeah. And one other question, are there any penalties if something is missed being redacted?
It depends on the state. Missouri, the bill that I was talking about in my conversations with officials in Missouri, they have had traction with their legislators just over the past week or two to get the language that was in the bill, which would have penalized recorders, to soften that language. But there is certainly interpretations that there could be strict penalties even if it's accidental. I know that if anybody has heard talk over the last decade about what happened in Colorado had has attempted numerous times to implement laws which would penalize the requirement for protected parties, that being law enforcement officers, and that would have absolutely come with prosecution even if it was accidental. It was the word publication was the word that was the key, and so any information that was published, even if it was done accidentally, could have theoretically come with those penalties. So it's important to look specifically at the language. Oklahoma's law talks about felonies. So it really is important to have conversations with these legislators and to say, what is really expected of our jobs and how are we supposed to do this when we don't have enough information and we don't have enough opportunity to be able to find the people whose information is out there. And of course, the vast amount of data that we have collected and aggregated and kept in the records makes this a really challenging task for anybody.
Thank you so much for sharing. I think it's a really important topic, especially for this group of people at the GIS audience that you have here. Their kind of mantra has always been get all the information out there. The more information that's public, that's online, that's free, the better. Mm-hmm. And we now know that there's probably things in the works out there that are trying to do the opposite and make records not public and not available. So
yeah, I will say one thing on GIS that we did notice here in Florida was with the way that the redaction law was implemented. Some counties do rely on the GIS data for large scale mapping of neighborhoods and counties. And when an individual's property was removed from the information system with the GIS data, it resulted in there being black holes over top of the people's houses. So even if you didn't know where the person lived, all you had to do was zoom in and you see a black hole over top of someone's house. It was pretty easy to figure out that that was a protected party. So another unintended consequence that really made itself readily available for fraud and also for people to be unprotected. It's might as well just park the cop car in your driveway at that point. So.
Oh, wow, that never would have thought of that either, and they probably didn't either when they
certainly did not.
These good intentions and who knows where it's going to lead. Okay, thank you very much for all that information, Lindsay.